All right, guys, we're getting ready for another Wedding Talk Radio. We've got a awesome guest today who's going to really, I don't know, put the nail in our coffin, or at least tell us how to pull the nail out. One of the two. He is a wedding industry attorney. He deals with weddings all the time and has a podcast as well that you might want to check out. So I'll bring him on board right now. Put your hands together. I feel like I'm out at an event as it is. For Rob Shink.
Hello, Kyle. Thanks for having me. Hello. Yeah.
Hey.
I'll clap for myself. There we go.
So, welcome. So you how long have you been practicing law?
Oh, it's a good question. I guess now about 12 years. I think I passed my first bar exam in 2008. So it's been 12 years, and I've been representing wedding industry professionals almost since day one.
Wow. Oh, and we do need to remind everybody, by the way, this is just a conversation that we're having. Although Rob is an attorney, licensed in the bar and all that kind of stuff, this is just a conversation. He's not your attorney. This is not stuff that you can take and apply to your city or jurisdiction or state or anything like that. This is just a conversation we're having that will help guide us in running our businesses a little better in the future. So we definitely advise you to consult your local attorney on anything that has to do with what we're talking about. So with that being said,
the CYA, there you go.
Yes, exactly. We got to make sure that we are covered here. You know, we are talking to an attorney. We got to do it the right way. So obviously a lot of things have changed. Everybody's contracts, I wouldn't say everybody, but a lot of people's contracts up until this point have been very simple. We discuss the words, do we use the word retainer or deposit? And that's about as deep as we ever got in our contracts. But now with coronavirus, all of that has changed, and we need to start amending our contracts to protect not only ourselves, but our clients as well, and their guests and everybody else around us on the things that we do. You know, one of the terms that I've heard bantered about lately is force majeure, you know. So can you dive in a little bit about that and what we should start looking for in the future?
More than happy to. The concept of money that is kept by the wedding professional, the event professional, when in the event that the client terminates or cancels the event or terminates the contract for reasons within the client's control, we typically refer to that as liquidated damages, meaning that if there's an amount that you want to hold on to or an amount that you want to be obligated to be able to be owed, if the client cancels that event under their own control, has its own set of rules. It's got its own special sauce.
Kind of like a retainer type situation.
Exactly. So when we're talking about retainers, we're talking about non-refundable payments, deposits. That's the world that's the bucket that sits in. You have another bucket with regard to what happens to money if the event cannot go forward due to what we've been referring to as a force majeure event. So let's talk about the force majeure bucket, and we can come back to the retainer deposit bucket. So force majeure is a contractual clause. Like, just because you have a contract doesn't mean that necessarily that a force majeure clause is in it. So when we talk about force majeure, we're just assuming that your contract has it in there, and every contract is different. So not every force majeure clause is written the same way. But the general idea of the force majeure clause is that neither of the parties are going to be able to sue one another for breach of contract if the event is rendered impossible to perform due to a quote unquote act of God or some other such thing that is typically listed. So strikes like labor strikes or tornadoes or hurricanes, things like that. So what that actually means is that it means that a client can't demand that an officiant show up at a wedding in the middle of a hurricane, or they can't sue a wedding planner for not showing up to an event where the venue has burned down to the ground. Okay. That's the general idea. It discharges a party's obligation to perform under that contract. Now, there's a few line of questions that we have to go through with regard to how COVID-19 and force majeure relate to one another. And Kyle, you can, interrupt me anytime if
yeah, absolutely.
if I'm blabbering. Yeah. So the first thing is that the force majeure event and whether or not COVID-19 is a force majeure event will depend on the contract, but almost none of your contracts are going to have pandemic in it.
Right.
But it's also going to be jurisdictional. So every state, again, has its own special sauce of what is considered a force majeure event. But I'm not going to bet my farm. I'm not going to bet my shirt, but I'm pretty certain that when you have a pandemic situation coupled with a government proclamation to shelter in place, or that your gatherings are illegal if there are more than 15 people, then that is probably going to qualify as a force majeure event, even though your force majeure clause probably doesn't necessarily say pandemic in it.
So,
Yeah, go ahead.
no, I was gonna say, so that actually brings up a question. So in there, is there a catch-all phrase, or do you have to spell it out? Like obviously we're in California, we have earthquakes. We don't really have tornadoes, but they're on the coast. There could be a tidal wave or a tsunami. Different parts of the country have different weather-related issues that could cause this. Do we have to sit there and start spelling it all out in case there's a fire, in case there's a tornado, in case there's an earth, and all of a sudden we've got 10 pages just listing out all these different items? Or can we be more general in the term?
That's an excellent observation. So you're right. No, it does not have to be a riot act. It doesn't have to be a litany of every possible thing. And that's why we're having this discussion, because you don't want a contract to be 10,000 pages. You don't want to have, asteroid hits the earth, alien invasion, terrorist uprising. Like, you don't need all that. Typically, the way force majeure clauses are written, it's act of God, such as this, this, and this. That does not necessarily exclude all other things. The idea is that the event is rendered impossible to perform. So just because there's an earthquake doesn't mean that the event can't go forward. You see what I'm saying? So then that's the issue, is that there's case law that exists where H1N1 is not a force majeure event. But H1N1, to my knowledge, never was coupled with government closures or government restrictions on events. And I think that's the key. But let's just assume that it's going to be a force majeure event, because I think that's likely where we're headed.
Right.
The next issue is, what are the obligations of the party? So the contracts that I've written over the past 10 years spell out the obligations of the parties, and hopefully yours does as well, which is to say that when you have a contract for a service that's in the future, hopefully there is a provision within the force majeure clause that says the parties will work together to reschedule the event at such time as the force majeure event is terminated. So hopefully it has that. And what that means is that you guys have to use reasonable or best efforts to reschedule the event. If you do not have that, then you are now within a gray area, and it's jurisdictional. So do you have to work with the client to reschedule? Unknown. Do you have to give money back? Unknown. If so, how much? It will depend on where you're at. It'll depend on the wording of your contract. And that's the rub. That's the problem, is because the only real way to know how much you have to give back, if any at all, based on what you've done, is going to be determined by a judge or a jury down the road if somebody sues you or you have to sue somebody. So I've been saying this for the past, 2 months now, 3 months, that every wedding professional, to the best of their ability, must use their sweetness and their and honey to catch the flies. Okay?
Yeah.
You got to use love to try to get these things rescheduled, because if you can't reschedule, or the client refuses to reschedule, you are now in a legal gray area. So you will be saying things like, well, I want to keep this much and give you back the rest, or I want to keep all of it, or whatever. And then now you're dealing with the issue of, like, are you going to be trolled online, blah, blah, blah. So that's the best thing that you can do. Moving, I'm sorry, go ahead.
I was going to say, so an example in mine, and actually I've had this for years and years. In my contract, I have my company name, And actually, it's well here. I'll share it real quick, like the screen, so you see it. So number 12 on here, I have our company name is not responsible for acts of God or other events outside of our control that result in the early closure of the event. Law enforcement, power interruption, weather, guest actions, stuff like that. So would that be a force majeure, or is that?
Yes, that's the principal idea. You're basically telling the client that the client cannot sue you for breach of contract because you can't complete the event, because if you show up to the event and you'll be arrested. So
Right,
that's what that's saying. And what I'm saying is that it says really nothing else other than that.
right,
Okay. And that's why you're now going to be in an area where, okay, well, what are my obligations moving forward? Your obligations are to do the best you can, because principally, depending on what jurisdiction you're in, if a force majeure event causes you to not be able to fulfill your obligations, then you're typically not going to be able to retain 100% of the contract value. Okay. If you have 100% of the contract value, in other words, if you have all the payments,
right.
because it's not fair, because the event can't go forward as it was supposed to. So the kind of the law, the morality of the situation that a trial judge is going to look at is going to say, okay, well, what value have you brought, and how much is that worth? And in some instances, that might be a certain percentage of the contract value. In some instances, it might not be very much. But like I said, you don't want to get there. You want to try to reschedule
Of
if at
course.
all possible.
So
So
here's actually an interesting, because mine obviously wasn't really dealing with. It was dealing with acts of God, but it was dealing with acts of God during the event, not previous to the event. Like a COVID or earthquake or tornado. Mine was
right,
more dealing with things that happened at the event. Now, if something is not deemed an act of God, let's say, and this really only applies to venues, DJs, photo booths, things that are elements at the event. But let's say we're at the event and you know the power goes out because of an accident down the street, or the both fathers got wasted and started a fight, and the police came and said you guys are done, even though we got paid till 11, the party ended at 9:30. Those are honestly more likely to happen than a tornado or a pandemic, we'd think anyways, but then again we had a pandemic anyways. um, how does something like that hold up? We got paid till 11, but because you fed them so much alcohol, they got in a fight and the cops shut it down. Are we, I know we're kind of veering off a little bit of COVID, but are we now liable for giving them back money?
excellent. So no, the answer is no. But you're
Okay,
right.
we stop there. I'm
We've
kidding.
left the yeah, we've left the domain of force majeure, because remember that force majeure is something that's beyond the control of the parties. Uncle
Right,
Jack getting wasted and punching you in the face is within the control of the parties. So, or theoretically is within the
right, right.
control of the parties. So if there is, and I'm not quite sure exactly, how to answer correctly, but you can make um, client behavior the responsibility, I'm sorry, attendee behavior, the
Right.
responsibility of the client, and make the client have to mitigate any issues with unruly guests. And you can make it a material breach, meaning that you can leave and keep the money if they don't mitigate that problem. With regard to the example that you gave with the power going out.
Hmm.
Now, and again, this is always fact by fact, and
Right.
there's case law to suggest that if lightning hits down the street and you're the only venue that the lights go out, then it's probably not a force majeure event. It's probably the wiring in your place, and that's within your control, and you would be liable for breach of contract in that situation. So again, like, there's a difference between force majeure, which is truly something that is without beyond your power.
Yeah.
And then there are things that are within your power, whether or not your computer works when you get to the event,
Right.
whether your hard drive shuts down. That's within your control. Even though for me it's in God's hands whether or not my computer works. Technically, that's something that you should be responsible for.
Right.
So these are that's kind of, and it's hard to differentiate that, because I mean, somebody's idea of an act of God might not be the next trial judges. So that's why it's a difficult area to parse through. But yeah.
It
So
seems relatively um really logic based. I mean, if people just stop and think for a moment, and we'll use the example of the power going out. Okay, that's clearly not necessarily. I shouldn't say clearly. Nothing is ever clearly, but not necessarily the client's fault. It's not the bride and groom's fault. It's most likely not the DJ's fault. But what if the venue didn't pay their power bill for whatever reason, or there was an accident down the street? That puts the burden on somebody different. Let's say that the venue didn't pay the power bill. Well, now I would imagine that the bride and groom, they still owe me money because I work for them, but they then might be able to go after the venue saying, hey, you should have foreseen this, paid your power bill, we would have had our party, but because of that, you owe us money that we had to pay all these other vendors and the loss of our event. So I can see where logic plays a part in here. Just stop and think for a moment.
Yeah, you've laid out like a great law school exam question. So in that situation, if you're like I said, the wedding venue was negligent or did have faulty wiring causing the power to go out,
Right.
and the DJ obviously cannot perform without power, and so therefore the couple is saying, well, I'm not going to pay the DJ because I didn't get no music. Well, in that instance, the client is in breach of contract with the DJ. Okay.
Right.
So the DJ would be allowed to sue the client if they were owed money. The DJ can sue the client, and then the client can basically interplead or bring in the wedding venue and say, look, if I'm liable to the DJ for not paying money, you're going to pay it.
Right.
So that's one way that would shake down. But you're typically the law is not going to hold you accountable for something that's not your fault. So I'm not going to say that you're not going to be sued as a DJ. I mean, there's no document in the world that's going to prevent somebody from suing you, but the document will help you be successful in that litigation.
And jumping back and forth and around all around here, something else. And I just bring up my contract because it's the only contract I have to share. But we are talking about guest conduct, and so something else that I've gotten here is number 9. Contact executor, because I do several things. I have a casino business. I rent casino tables, DJ, stuff like that. So the signee may not be a bride. It might be a corporate event. It might be somebody different. But nonetheless, I'm saying that by you hiring me, you're responsible for your guests' actions. If they steal something, and I've actually had that happen before, if they attack, the DJ or my setup guy, or they're responsible. I can't take the name and number of every person walking in the event to say, oh, okay, well, I'm going to go ahead and talk to, Leland or Lauren, or I don't know them, but they walked into your event where you invited them. And so I'm holding you responsible for their actions.
That's right. That is a common contractual term in contracts like this. Yes, you can do that. And then how that would play out is you could sue the client under that clause, and then it would be up to the client to bring in the offending party. And that's not, necessarily going to be ironclad. There are going to be instances in which the client would not be liable for certain conduct, but for the most part, that is the case. You can absolutely do that. Okay. And you do casino, like casino night stuff?
Yeah, yeah. So awesome. Like if you were having a birthday party, you might call us and say, hey, it's my wife's 30th birthday. We don't want to go too far. And
what's funny for me is like this is the compulsive gambler in me. And I have been addicted to this YouTube channel where it's a guy playing those ridiculous, but it's high value quarter machines where you put the quarter in and it falls and it pushes quarters and it pushes.
Oh yeah, yeah. Yep.
I watch those things, like just let my mind go, and he maybe he wins, maybe he doesn't win, but it's anyway.
That's your version of cat videos, huh?
It really is. And it's like I'm sitting there and I'm like, why am I watching this? Because it's just this goofy tray going back and forth with the quarters. But so how it works is that, and I'm sorry that I'm wasting that time.
Oh no.
He buys in for like $500, but gets $20 worth of quarters, and so you're putting the quarters in there. And it might be a Bitcoin that falls out.
Right.
Or it's like $1,000. Anyway, so I've been watching those things. Sorry.
Wow. Interesting. Yeah, no, what we do real simply is we bring the tables to you: blackjack, roulette, craps, poker, bingo, whatever, dealers, funny money, everything. And we have a party. It's a lot of fun.
That's awesome. The laws are much stricter for that in Georgia than they are in California.
I would imagine they are, but it's also in how you do it. And again, I'm definitely not an attorney, and you would know more than I would. But um, we there's no buy-ins. You walk in, and it's completely free to play. And I give you a $500 bill. You play. At the end of the night, you turn that in, and we give you raffle tickets, and then we give away a prize,
A fake $500 bill.
fake $500 bill, and you didn't pay for that. So, because you were a guest at the event, so it was completely free. So, anyways, on to bigger and better things. So,
Right.
we talked about force majeure, and we talked about contract amendments moving forward. Um, what about? I'm trying to think here how to really, if somebody is already contracted with you, you know, and obviously, I've had several weddings that are postponed. Actually, I've had a couple weddings that I haven't even talked to, but their wedding was, supposed to be 3 weeks ago. I haven't talked to the bride, but not for lack of reaching out. They're just moving on. Um, what is my responsibility for refunds or the retainer? Because I talk about retainers, and I haven't gotten the full amount, but I gotten some amount from them. So what's my responsibility going forward in that?
So my stance on this is that, again, it can depend on your contract language. It's going to depend on what state you're in, but by and large, the concept in the contract of the non-refundable retainer or deposit typically is with regard to the client canceling for the reasons that are within the client's control. And when there is an event that's beyond the party's control, case law supports that the judge is going to disregard the non-refundable language of the contract, because this is not something that the client did. It's beyond the party's control. So that part of your contract, you can argue that, and you can tell that to the client, like, hey, my deposit or retainer or whatever is non-refundable, and that applies to this situation. You can argue that. But I think if push came to shove and this was actually being reviewed by a trial judge, the judge is going to say no based on case law. That's separate. So what are the obligations of the parties in a force majeure situation? It's like I said earlier, where it's a gray area. Some states and some jurisdictions are more likely to allow you to keep expenses if you've gone out of pocket, or whatever would compensate you for what you've done. The problem is that's much different for a coordinator, a wedding planner that's been working the whole time, versus a DJ who theoretically, unless they're, have come out of pocket for lighting or a rig or special software or retained personnel, you've saved the date, right? So the idea of how much you need to give back at all is not static. It is going to be case by case, and I can't give a good answer to that, and I don't think anybody can. So that's why I'm saying, like, the maximal solution is to try to reschedule.
Right.
Because what's going to happen is, if you want to lowball the refund to the client, they're going to get mad at you or that kind of thing, and you don't want that.
Right. Yeah. I'll probably say this a dozen more times, but it really just comes down to common sense. Just stop and think about what would be fair for both parties and logical. Did you put some time in? Did you do some music editing or remixing for them for their event? Did you put time in? Did you make some effort here?
And you're right, but and also at the same time, it's kind of like in certain scenarios, everybody's got guns pointed to their heads, because the vendor, like, can say, okay, well, I think that you're owed this much, and the client can be like, that's bull crap, I want more than that, or whatever. Then
Right.
the option for the vendors to go, okay, well, I'm going to go out of business, and you're going to get anything. So there's incentive for both sides to work. And just because you need to give a refund to a client doesn't mean that you've got to give 100% of that refund tomorrow. Like, be like, look, the best that I can do for you, unless you want me to go out of business, is I'll give you 50% of it back in 60 days and the rest in 90 days, or something like that. There's no law that says if you have decided that you need to give a certain amount of money back, that it's got to be tomorrow and it's got to be the whole thing. That's
Right.
on your side. On their side, it's like, well, I mean, maybe I'll use you in the future, maybe I won't, you know, that kind of thing. So there's arguments on both sides where everybody is coming from, you know, so.
Yeah. Shelly actually has a question for you, so I'm going to bring her on real quick. Shelly, go ahead.
Hi. In reference to our conversation we were just having about that, you know, as a planner, I do have a lot of different steps that I go through. Is there any way to change the verbiage in our contracts to say, you know, if the first third is for pre-work? That's bad, you know, poor use of a word, but pre-work. The second deposit would be for work done the month before, and the third installation would be the final payment for work the day of. So let's say we get all the way up to the day before the event and we get another pandemic and cannot perform the job. Is that a good way to prevent ourselves from having to go back and return the first payment and the second payment, which usually we call this, you know, deposits and down payments?
The answer is yes. So let's and I want to address this both with regard to the retainer and the liquidated damages concept, and as well as the force majeure concept. Because again, who's entitled to keep what is going to be different based on those two buckets. So let's talk about the force majeure bucket. So, I promise, Shelly, I'll get to the retainer part. So, but I want to highlight the force majeure thing first. So with regard to, is there a way to write our force majeure clauses such that we keep the money? Yes. So the first thing you want to do, until there's a vaccination, we're going to be in this exact same situation regardless of what happens, because there could be flare-ups, there could be whatever. So the first thing is to make sure that, you know, pandemic situation is explicitly placed in your force majeure provision, okay? And you can define that as whatever you want. I would advise not just saying pandemic. You need to make sure that it's pandemic is defined, and you can define it, you know, however you want to. Pandemic shall be if an infectious disease or COVID-19 is the cause of a proclamation that says that, you know, gatherings are limited to 100 people, something like that. You define what pandemic is. The next thing is that you obligate the parties to reschedule the event if the force majeure event is triggered. Okay, so if there is a pandemic situation based on what you defined it as, then the contract will continue, and you will try to reschedule, making it obligatory on the parties. The next thing is that's when you assign the risk of the force majeure event. So you make the client on the hook if there are additional fees, because sometimes, depending on, you know, I don't think there's any floors here, but flowers will be a different price if the date of the wedding goes from June to next November. You know, I'm trying to think of a proper analogy for a DJ, maybe like the licensing, you know, maybe new songs will be more expensive in a year than they are now. I don't know, but you put the client as responsible for any additional charges. However, you make the client understand that if the client refuses to reschedule, or that you cannot reschedule within a certain time frame, then they forfeit the money, that the money stays with the vendor. And that is, the parties are both acknowledging that that's what's going on. You have to make sure that's explicit and not tiny and hidden. So that's something, those are some things that you can do with regard to keeping money if a force majeure event happens, and particularly if COVID-19 happens. Now let's talk about Shelly's excellent example of retainer language or non-refundable language. The idea in the law that you keep money or you're owed money if the client cancels the event, that's liquidated damages. And in California and in a lot of states, there's certain language that's required in order for the liquidated damages clause to be enforceable. First of all, it requires that you acknowledge what the triggering event is. So if client cancels, okay, the event, so they're cheating on one another, they just don't want to get married anymore, they hate each other's guts, that's the triggering event. So you want to define whatever your triggering event is. The next thing is exactly what Shelly said, which is what does it represent? What is the money that stays with you, or what is the money that is owed for. Okay. So like, as you mentioned, like you don't have to get into explicit detail, but you know, it can be acknowledged in a couple sentences. I do things months and years in advance that you'll never know about. I retain secondary personnel. I'm developing, you know, things on software that you don't see. I'm retaining equipment, this type of thing that is special to your event. And that's why this money is owed to me, or I'm retaining it. The next thing is that you want to get the parties to acknowledge that this is a fair representation of that work that you just described, because there is a quirk in the liquidated damages law, and that is it can't be a punishment. It has to represent your reasonable exertions throughout the duration of the contract. So the example that I typically give is, if your liquidated damages clause says, if you cancel this event, you're going to owe me 5 times the contract value. That's a punishment. And that's designed to not as a mechanism by which you're compensated. It is a deterrent. It is trying to keep the client from breaching the contract. And you cannot do that. You cannot have a liquidated damages that is not in some way reasonably related to the damages that you would get if the client cancels the event. So that's the retainer, quote unquote, bucket. That's what typically what you would want to do in order to be able to keep money that you've been paid or be owed a certain amount of money. Now, let me just say this, and even though I've been talking for 10 minutes, because it's super important. If you set up your payment, however you do it, if you set your payments up such that if the client cancels and you want more money, or you need more money, or you're still in the hole in a certain way, then you need to structure your payment program such that you're not going to be hurt if the client cancels the event through the duration of the event, because you will never get money from the client if the client cancels the event. You will typically only have the money that has already been paid to you, if that makes sense. Yep. It will never be a good idea to sue somebody for breach of contract to get the rest of your money. So if you need to make it 3 payments or 4 payments throughout the duration of the contract that are non-refundable, then that's what you need to do.
So that actually kind of brings up another question. See, everything leads to another question always. So how do we structure our value? I can't say, you know, well, I'm worth $1,000 an hour and I put 3 hours into your services, so therefore, you know, you owe me $3,000, and that's not logical. It's not reasonable. How do we determine, you know, what is our value? I mean, I know some of that's up to us, but really it's not, you know?
Well, I mean, I'm not an Alan Berg, you know what I'm saying?
Right.
Like, it might be an Alan Berg question, but as long as you're reasonable in that, and that it wouldn't appear to somebody that you're trying to prevent the client from breaching, you should be okay. So like, but my humble recommendation is I start with whatever my out-of-pocket expenses are.
Mm-hmm.
Okay. So, if on day one, when they sign the contract, you get a certain percentage. If you're going out of pocket typically for equipment or secondary personnel 90 days before the event, then maybe that's a good time to get another payment. And the payment should in some way reflect the fact that you've gone out of pocket for that.
Right.
If your payments are such that it's literally, you don't come out of pocket, and maybe you're doing planning, maybe you're not doing planning, then you're really falling back on the argument of, look, it's, you know, and that's why the liquidated damages clauses are so good, is because it's preventing you from having to prove this later. But your arguments are, well, I have not taken any other clients for that date, so that's worth something. And you know, I am, you know, I'm dedicated to coming out there and doing it. You know what I mean? That's, and right. So, and if you breach, it's not as though, and this is the misconception that and Alan Berg would probably be a good person to talk about this, but there's a misconception that if the client breaches, it's like, oh, awesome, I get a free day. No, like I don't get to eat. Like I you know what I mean? Like I'm losing money that would pay my mortgage. So that's what you're really falling back on, those 2 or 3 arguments. If you're not coming out of a pocket for something and you're not really doing anything,
Right.
those are your arguments, and those are still strong arguments that would support a liquidated damages installment payment program, if that makes sense.
It makes sense. I mean, I look at it, and you know, on my end, I figure, and this is not true across the board, but on a general basis, as a DJ, I probably spend about 35 to 40 hours per event. And that's everything from client consultations to music research for their particular event, to whatever it might be, all the little things, cleaning the equipment, you know, whatever it is that makes their event go off seamlessly. It typically between 35 and 40 hours, including the event time. And it's also driving to the event and coming home from the event and whatever, all of that. So I took that and I divided that by, you know, what I want to make at a typical 4 or 5 hour event and go, okay, that's what my hourly rate works out to. It's about $50 an hour, more or less. So that's kind of how I've come up with it, even though additional hours aren't $50, but
I would argue that if you base your liquidated damages clause on that calculation, I don't see how that could not be fine.
Right. And again, it's not me going, well, I'm worth $500 an hour. That's,
no. Yeah.
You know, we're being reasonable here. So,
yeah. So,
that's,
yeah. And so again, like another example, like if you say I want 100% of the contract value on my first payment and it's non-refundable, that is not a reasonable approximation of how you'd be damaged if they breached the contract by canceling the event the next day. So,
yeah. And that's part of stuff I can only have my contract to reflect on, but I've got in there actually a breakdown of timelines, you know, 8 weeks before the event, the balance is due, you know, 4 weeks before the event, it's not cancelable at all. I mean, you can, but at that point we're 4 weeks out. All of the work's been done. We're prepared for your event and you got cold feet. I'm sorry, I've canceled other events or not taken other events. And so, but I've got it laid out. That's my other question for you though. So to keep my contract small, I have some of the major items in there, acts of God, things like that. But I also have a link in there that links to my website that has all of the terms and conditions. Do those hold up because they're not necessarily in the contract? And I guess theoretically, I could go in and change those anytime. It's not in the paper that they signed. So do they have any value?
That's actually a good question. I've never heard of any wedding professional ever doing that. I'm not saying that you can't do it, because contracts all the time incorporate by reference, meaning they ride along with one another, other documents.
Right.
The issue for you, because you're not like, this isn't like a matter of your licensing agreement with Apple when you download a podcast or something, who retains the right to update their terms and conditions of service. Typically, actually, it's a good question. So like, I think that you'd be safest. I'm not saying this is, 100%, but I think that if in a situation where you're saying, I operate under a certain other amount of terms and conditions, you can read them here if you want to, but otherwise, if you sign this contract, you're agreeing to them because I'm incorporating them herein or whatever the language you're using. As long as you identify that there is another document they should read.
Well, here's what I got.
Well, I can't give you. This would be reading this and then talking about it would be giving legal advice, and I don't want to do that.
No, you're not. I want to
general
link, and that's that.
Right. Okay. So if the language was something along the lines of, here's a link to terms and conditions that you're agreeing to by signing this contract, you're safest by always keeping the terms and conditions in a file. Okay. So like if they signed it in October of 2019, then you need to make sure that you have a copy of the terms and conditions that were in effect in October 2019, because I
Right.
I can't say offhand, but typically they're kind of only agree to what they know about then. And if you have the unilateral power to change the terms of your DJ contract or officiant contract,
Right.
then there is some argument, especially in California, that you might not actually have a contract. So I think that you're safest by doing that. So that way, if you do change it, the changes won't apply to anybody that's already signed it.
Right. One of the little side note on how people might be able to third party their agreement part is there's a website out there called archive.org. They're that's exactly what they do. They archive websites, and if you register with them, they check your website out all the time, and they archive all the pages. So you could go back and say, look, judge or whoever, you can
Mhm.
see on October 19th, this is what my terms and conditions look like. On December 4th, this is what they look like. And it's by a completely independent website that does nothing but archive websites.
Right, right, right.
So just kind of a little side note. So my next question for you is has to do with liability. So, you know, bride and groom, we're a client because we don't do just brides and grooms, hires us. We come out, and me myself, I a little bit. I have allergies. You know, I sneeze once in a while if there's a little bit of dust or whatever, and all of a sudden, a week later, you know, Aunt Susie got COVID, and she turns to me and says, "You got my Aunt Susie sick, and now you're liable." And you know, how do we deal with that, or how can we prevent that?
That's an excellent question. So, and I have a couple of podcast episodes coming up where I speak with an attorney about who's a trial attorney that actually defends venues. So, like, if it'd be Auntie would be suing you, she would come in and defend it. So, it's really going to be a really great episode. But the
Awesome.
long story short is this: everybody is responsible for acting reasonably. If you don't act reasonably, and as a result, you injure someone, then you could be liable for damages under the theory of negligence. So Aunt Susie, in your example, would file a claim against you, a negligence lawsuit, and she would have to claim that you were negligent somehow, and that your COVID-19 caused her COVID-19, which that's the rub as far as I'm concerned. That was going
Right.
to be the most difficult part. So what are some things that you can do? Okay. You are not responsible for Aunt Susie contracting COVID-19, even if you had COVID-19 and gave it to her, if you were not negligent. Does that make sense?
Right. I didn't go up and kiss her or something, or
Right.
you
Okay.
know, on
So the
purpose.
issue then is, how can we act reasonably and not negligently with regard to COVID-19? So there are several things that you can do as a business owner, especially if you have employees. And that is, start with, and even if you're by yourself, have policies and procedures. So, Wedding DJ Incorporated of California have implemented policies and procedures where we're going to, we wash our hands, we disinfect all of our equipment, we have hand sanitizer. Anytime I touch something, it gets disinfected. We're going to wear masks, this type of thing. That will help. And then make your employees do that. And then when you get to the event, that's what you do. And even when you're contracting with the client, when you're emailing the client, like, here's my contract, sounds great, $1,000, whatever the case may be. Oh, by the way, I'm attaching my policies and procedures, because that's going to actually help. We'll come back to that in a second. So, okay, so you have your policies and procedures, and then you actually do them. You actually go forward and make sure that you wash your hands, you sanitize and stuff like that. So the idea is that if you're adapting these policies and you're basing these policies on like CDC guidelines, or to some extent what other wedding officiants or what other wedding DJs or what other event professionals are doing as well, then that's probably the standard. Okay.
Okay.
And if you're adhering to the standard, then you should be okay. But also with regard to attaching your policies to the email or your communications and giving it to the client, it's almost like you're saying, hey, listen, if this isn't good enough for you, don't sign my contract.
Right.
You're assuming the risk almost in a way. Okay. So that's from a business standpoint of conduct, how you could be less likely to be liable for giving somebody COVID-19. Now, there's also the concept of waivers.
Right.
And I have an episode out actually that's about that already. But the idea is you can get a client to sign away your liability for negligence. Okay. Some states don't allow that at all. Some states say, okay, we'll let you sign off negligence and gross negligence. Some states will say no, no gross negligence, but negligence is okay. It just depends. In other words, the client is saying, even if you are negligent and I get sick, I'm not going to sue you.
Right.
However, those waivers are only good. Again, it's only good if they're allowed, but they're only good for the person that signs them. So Aunt Susie, unless Aunt Susie is your client, it's not going to work.
Gotcha.
Now, there's another idea where you make a huge poster that says, if you walk through these doors, you're a champion. No, like whatever the Notre Dame, because I can't remember, play like a champion. But if you walk through these doors, you're waiving liability for the negligent actions of DJ or whatever. But
right.
There depends on what state you're in, what jurisdiction you're in. And I don't know, like those things always seem kind of fishy.
It kind of reminds me what you were mentioning of a couple of other industries. One of those being the movie industry. If they're filming at a bar, they put a sign up saying, by coming in here, you're agreeing to allow us to use your likeness and your voice in our whatever video it might be. And, same thing goes if you go to an amusement park, there's a small, obviously, very small risk, but you get on a roller coaster, you might get motion sick. You might, something might happen. You're taking on a certain amount of risk by entering the park. So I can imagine that there's something there.
Right. And like your gym, like I know like LA Fitness has those type of things in their contracts too. But again, whether or not they're enforceable will depend on what industry it is. And like some industries like hotels and Airbnbs, you can't have them in some states. So right. Even in states that allow you, some industries you can't, because there's policy rationales why we don't want to do that. So
I would also imagine that everything's as enforceable as the client believes it is.
Yeah, I mean, you're right. There's nothing that's going to prevent you from being sued. But the issue is, will it get kicked out at the entry level if the contract is right? And yes, so that's how that works. So
yeah, I guess what I was more alluding to is, if the client believes that because they signed the contract and it says the full amount is due, and they're like, okay, well, it says the full amount's due, and then it's, we're all good, even though it may not stand up in a court of law. There are some things that are just based on belief.
Oh yeah, power perceived is power
exactly.
achieved. Gotcha. Yeah.
Are you speeding if there's no cops around? I don't know. So Shelley actually has another question for you. So Shelley.
Yeah, in terms of the liability and assuming the risk for being a planner at these weddings, there's been some talk about, should we bring sanitizer? Should we bring masks? How much of this is really our responsibility? And my question to you is, if we go out there and we're bringing extra sanitizer and we're bringing, extra masks and we're wiping down counters and doing all that stuff, are we automatically assuming that risk? Or are we better off just staying away from all that? You're on your own, folks. You didn't bring a mask. Sorry, I'm not going to take anybody's temperature. I'm not bringing extra hand sanitizer. Where is that liability falling in if we cannot get waivers, which I'd never want to bring a waiver to a wedding and make every guest sign it. I think that would be ludicrous. But
so
I do the right thing.
Right. I think from a large standpoint, most people, including trial judges, are going to say, where society's better off you performing that event than not performing that event once, you know, we understand the reasonable approach to limiting the transmission of the disease. So the issue is, well, Rob, like, okay, well then what, I'm bringing gloves or not bringing gloves, like what do I need to do? And the issue is, it's going to depend on what jury you get. And the most states, it's an objective standard based on other individuals in a similar situation. So, I mean, the best advice I can give you is to go to the CDC website or go to the California, if you're in California, Shelley, I can't remember.
I'm in
She's in Pennsylvania.
Okay, go to your Pennsylvania Department of Community Health. I'm not sure what you have there, and find out what they're recommending and adapt as much of it as you can. Then get on the horn and call everybody else and find out what they're doing. Because at the end of the day, if there is an issue with that, if you can say, you know, to the jury, Shelley did what was required or what was recommended by the state health department, and she found out what everybody else was doing, there's no case. Because just because it happened doesn't mean that you're at fault for it.
right.
There's the concept of negligence. So, like, you know, well, Rob, am I being reasonable by not bringing masks for everybody? I would say no, but I'm not on your jury. And I don't think that there's anything in the recommendations that says that you, because you're the planner, are responsible for other people's PPE. You are responsible for, not you specifically and your people, your employees, not transmitting it. I would say if somebody could make the argument,
No.
and I'm a plaintiff's lawyer, but somebody could make the argument, but I don't think it would be very strong to say, well, Shelley came into this place and all of her people had masks, but they didn't give me any masks. Like, no, I don't think that's, I would say that's not reasonable. And that's kind of the thinking. That's what people will be arguing.
But it's like, if as a customer service person also, now this also takes into account people that don't have a venue, that let's say they're having it in their yard, in their home, in a tent, which I'm sure we're going to be seeing a lot of that.
Yes.
If I'm trying to do the nice thing and provide that service, and, is it something that would come back to haunt me because I provided it and it didn't work, or,
you didn't bring enough?
I didn't bring enough, or they didn't get, they got it anyways. And,
Right.
and now I'm negligent because it didn't work.
Okay. So, that's actually a good question. So some of that question is an Alan Berg question. Like, what should I do in terms of customer relations? I'm not the person for that. However, like, well, Rob, what happens if the mask doesn't work? What happens if I don't bring enough masks? Again, the question will be, did the plaintiff in that lawsuit, the person that got COVID-19, did they get it because you were negligent? So if they're going to argue that you're negligent because you didn't bring enough masks, they will probably lose, because that's ridiculous.
Mm-hmm.
And I mean, is that a law somewhere? No, that's Rob's law. That's ridiculous, because everybody has a duty to one another, and you have your own duty. And no one is saying, at least that's what no one is saying that you have an obligation as the planner, even for an event that's at somebody's house, to have PPE for everybody, unless for some reason you told them that you would.
Mm-hmm.
Then maybe. Okay, so we'll put that in a category. The other category is, what if the hand sanitizer doesn't work? What if the mask doesn't work? Well, those are issues with the hand sanitizer manufacturer or the manufacturer of the masks, not yours. If you are following, and again, who knows, but if you're following guidelines and the recommendations and you're doing what normal people would do in your community, then you're probably going to be okay. Even if you don't, the standard of care is what we call it. The standard of care is not going to require you to have, a truck full of PPE come up into the event for your event. I don't think that's going to happen.
But what happens when they kind of, if you've got clients that are like, look, it's my wedding, I'm not having masks. Is there a loophole that I can get out of it if I don't want to be part of that whole, situation? Like we were talking earlier, buses, for example, transportation and shuttles. if they don't want to pay for twice as many buses to give everybody social distancing on those buses, then, you know, if they want to just go ahead and pack everybody on a bus,
I think
part of that.
I apologize. I understand what you're saying now. It's really, it's protecting you from a client that's not adhering to the guidelines. Okay. The answer is yes. You can contract any way you want to. So in the same way that we talked about a client being unruly and maybe grabbing your butt or something like that, you go to the client and say, Uncle John is grab my butt. And if you don't get him out of here, or you don't tell him to stop, then you are in material breach and I'm free of any further obligations to you and I'm leaving. Mm-hmm. That's kind of the idea. So you can't do this for contracts that you've already signed unless they agree. If they agree, you're great. But it's the same principle. Your adherence to either my policies and procedures or, you know, whatever objective third party you want to make, like CDC or your state, is material to this contract. So if you are not going to agree to wear PPE or whatever the case may be, mm-hmm. then that will be considered a material breach, discharge my duties, and I'm going to keep the money that you've already given me, and the contract will be torn up.
Okay.
Kind of another follow-up question to that, because she does event planning and she sometimes brings in other vendors and they're paying, let's say you bring in the DJ and you bring in the officiant and you scouted the venue, and they're paying her for all of those services, even though those are independent contractors outside of her control. Is she responsible for what they do and the actions that they take or don't take at the event?
Typically you're not responsible for torts committed by independent contractors. You would be, under the theory of respondeat superior, be responsible for the torts of your employees. So if you have hired independent contractors to do something at that event, then in whatever document that is memorializing that, like whatever documents you have with the independent contractor about where to show up and what to do, then you can obligate them to do stuff. You can make them wear PPE and you can make them adhere to your policies and procedures, or otherwise I'm going to find another independent contractor.
Right. Okay. Well, cool. I mean, does anybody have any other questions? I think we've exhausted a few of them, unless you have something that you think has come up before that we didn't cover here.
Man, you guys have hit on everything in the kitchen sink. Like, this has actually been this is a really good, like, question and answer. Like, there's just some things that I have not considered before. Wow. Some of the stuff I haven't considered ever. So wow. that whole setting, the terms and conditions being on another website, I've never done that for a wedding professional. I've done that for websites and stuff like that, but not that's interesting. But no, I can't think of anything right now, literally as I sit here, that we haven't, that's COVID-19 related that we haven't.
Right. Or now you have some, not contracts, I guess amendments and stuff like that, and some verbiage that can help people out on your website, right? Or do they via email, or how do we do that?
Right. Sorry about that. Yes. Thank you for that, because I forgot. So yes, I own a contract template company called Wed Forms, where anywhere you are, you can buy a template that you would take to a local attorney or not and begin to use it. And that company is, and I've drafted all the templates, but right now for free, that I'm offering through that company a document that you would use if you and the client have agreed to postpone the wedding. So it's a contract amendment template in the age of COVID-19. So that template would address the postponement and rescheduling, as well as what a force majeure event is, how it would apply if it happens again, who assumes the risk, that kind of thing. It comes with a little guide on how to use it. So you can get that through emailing me at rob@weddingindustrylaww.com, or reaching out to me on social media somehow and let me know that you want it.
Okay. Well, here's the website here. I brought it up to kind of take a look at it, so people can see what it looks like. And as far as your email address, the website, how to get a hold of you. All of that we'll have in the show notes as well, all the links. And we'll even maybe have a copy of the form, the current rendition of the form. And we'll update it as we get new copies of it.
Sounds good.
Make it available to everybody.
Great.
So this has been amazing. A lot of great information, and things. I think a lot of this stuff is stuff that we should have thought about before this. This has just been a catalyst to make us really stop and go, wait a minute, I do need to protect myself against this or that or the other. It's been amazing.
Yeah. Thank you.
Yeah. So how do people get a hold of you if they have other questions, or actually want to use you as an attorney? I mean,
I think the best way is to email me at rob@whitingindustrylaw.com, or you can, I guess, reach out to me on Instagram or, through Instagram. I'm not on Twitter very much anymore. And like and subscribe to my YouTube channel.
Yes. And we'll have a link to the YouTube channel on our website as well. So that'll all be in the show notes. You can do that and be a part of it. And I know you're going to be at Wedding MBA this year, as long as it happens anyways. And it looks like things are going to happen. So if you want to see Rob live, he'll be speaking at Wedding MBA in Las Vegas this fall.
Good.
So come on out and make sure you get a good seat at the class.
That's right.
Bring all your questions with. So thank you so much for being here. I really appreciate it.
So much. Awesome.
Yeah, thank you.